Does a presentation with high-quality paper give you goosebumps? When you hear LaserJet printers printing, does it sound like a pastoral symphony? If so, you might be gear-centric, someone who knows that the right office gear helps you do great things. And at Office Depot and Office Max, we have the quality printing gear you need. Right now, get a 10-ream case of paper for only $24.99 and save even more in rewards. Office Depot and Office Max. Gear up for great. Limit 2. Offer ends 1/24.
As a retired teacher, I look for ways to save money for the things I love, like traveling the world. Medicare plans change each year. Fortunately, my Health Mart pharmacist helped me understand my insurance, saving me money on prescriptions. And they can help you too. My pharmacist cares about my health and the things I love, whatever that might be.
Health Mart, caring for you and about you. Visit healthmart.com for the locally owned pharmacy near you.
Well, okay, here we are. Justice for all for the next couple of hours. I'm George Yates. How are you? It's a nice rainy day out there, and it's I love that Lindley tune. Talk to the lawyer. Anyway, so here I am. I'm a lawyer, but don't hold that against me, okay? I don't know what what's the latest now. How many people? It's always like it's like Congress. Everybody likes their congressman, but they don't like Congress. Nobody likes lawyers until they're in trouble, and then they love their lawyer. So anyway, hopefully they'll love me. Anyway, so here we are with Justice for All, another week. And, today, the first hour, we're going to be talking about the United States Supreme Court. And it's a pretty interesting thing. Everybody knows about the Supreme Court. It's every time they make a decision, it's kind of a big thing and makes the newspapers and all the news and talk shows. People talk about the decisions and all that kind of stuff. A lot of people probably really don't understand much about the Supreme Court unless they're, constitutional scholars. But we have a constitutional scholar on the show later on in about the next 20 minutes or 25 minutes. His name is Erwin Chermeninsky. He's a professor from California, University of California, Irvine. He wrote a book called The Case Against the Supreme Court. We're going to have him on a little bit. So I was going to give a little background on what we're going to be talking about with Erwin Chermeninsky, the professor that wrote this book. And, for those of you that are, let's face it, most people are not lawyers or go to law school and study the Constitution and all of that. People go, what is the Supreme Court all about? And where do they even get this power to do the things that they do? A lot of people don't really realize the Constitution does not give the Supreme Court a lot of power to overturn decisions. That was a decision that came first about in 1803 when Justice Marshall decided this case called Marbury versus Madison and declared a federal law unconstitutional. And that was the first time. And John Marshall said, and John Marshall went to the College of William and Mary, and his statue is right up there. I was up at the law school at William and Mary earlier last year, I guess. And there he is, the famous John Marshall, probably the most famous and most influential Supreme Court justice of all time. And he comes from right here in Williamsburg, from the College of William and Mary. And John Marshall wrote this decision in 1803, Marbury versus Madison, which gave the Supreme Court, it took the power that said, the Supreme Court, if they decide that a federal law is unconstitutional, they can declare it unconstitutional. And because justices have all this power now over the course of the last 200 years, that has just become an accepted thing. And that if, let's say, the justices want to come out and decide whether or not the Affordable Care Act is constitutional or not, then they can rule on that. Congress can always go back and pass another law that maybe fits with whatever the Supreme Court says was wrong with the other one, but the fact is they can rule something unconstitutional. And throughout our history, the Supreme Court has ruled on many things that have had enormous impact on the rest of our lives. And it is kind of fascinating to go back and study the history of the Supreme Court. And Professor Chermeninsky, who will be on our show later, makes the premise in his book that the Supreme Court really, in many respects, has failed in its purpose. You know, we have a democracy, or actually a republic. We have a representative democracy. We don't have a direct democracy. We have we elect our officials, and then our officials go to Washington and they make the laws. So it's not a direct democracy. It's a Republican form of government. But in our Constitution, the Supreme Court, or based upon our Constitution, the Supreme Court comes out and makes various rulings. What is the most fascinating thing about what the Supreme Court failed to do in the first, really, 150 years of its existence was its absolute abysmal record on race. And here we are, you know, so much of the things that we talk about today in our modern media with the Ferguson and the Wilson police shootings there, and so many of the racial problems that we seem to be recurrent in a society today, to some extent have their origins in our Constitution and in our Supreme Court, and we just can't avoid that. You know, the whole word slavery is not mentioned anywhere in the Constitution, and we talk about the Negro race in the Constitution, and they were not citizens, of course, and they got represented 3/5 representation and so on in the states. And after the Constitution was ratified, for many, many years, every single time there was ever any kind of decision to be made about the constitutionality of slavery, the Supreme Court just basically upheld the rights of slave owners, and when in fact the Supreme Court could have done something about it. When you read Chermeninsky's book, you somehow feel the Supreme Court in the Dred Scott decision, which was came about right before the Civil War, ruled that no matter what laws came out saying that freed black slaves could become citizens, the Supreme Court in the Dred Scott decision said that they could not be citizens, and that, and in fact, the Missouri Compromise, which was entered into in order to deal with this idea of new states coming into the Union. Many people opposed slavery, other people wanted slavery, and so they came up with this Missouri Compromise, and the Dred Scott decision determined that slaves were not citizens. And boom. It wasn't too long later that we were in this Civil War, which was fought over the whole institution of slavery. So after the slaves were freed and the 13th Amendment was passed, and those of you that have seen that Lincoln movie, where the whole movie is really about Lincoln getting the 13th Amendment passed, which legalized slavery, and then not long after the 13th Amendment, we had the 14th Amendment passed, which was the Due Process Amendment to the Constitution. And not long after this was, for the longest time, we have slaves now freed, and we have, you know, free Negroes, let's say, or former slaves in the country. So along comes this decision in 1896. Now we're talking in 1896, more than 100 years after the passage of the Constitution, and there was a decision, Plessy versus Ferguson, where it was really a test case. And Plessy versus Ferguson was the old the rule that says separate but equal. It was we all know about separate but equal. We've heard about that. So here we are 100 years after the passing of the Constitution, and now the Supreme Court, when it could have said, no, separate but equal is not going to pass. In fact, the justices which passed that decision 7-1. The Plessy versus Ferguson decision, 7-1 in 1896, said, oh, well, the fact that we're segregating the races does not necessarily mean that we're considering one race inferior to the other. I mean, implicit in these decisions was, in fact, this fallacy that was ingrained in American society for more than 100 years, that the white race was the dominant race and that the black race was just basically fundamentally inferior. And it was ingrained not only in the way the Constitution was passed, and also it was mentioned in the Dred Scott decision. And in the Plessy versus Ferguson, of course, the justices said, oh, well, we're not saying here that the white race is dominant and the black race is inferior. We're just saying that separate but equal is okay. And Justice Harlan, who was the dissenting justice. There was only one dissenting justice, and Justice Harlan was one of the greatest justices in the history of the Supreme Court. He wrote a very vicious dissent in the Plessy versus Ferguson case, saying that this decision will go down as one of the worst decisions in the history of the United States Supreme Court. And indeed it was. But then do the math, ladies and gentlemen, 1896 to 1954. Because in 1954, we have heard of this decision called Brown versus Board of Education. Now, Brown versus Board of Education was the decision that finally said that separate versus equal is not constitutional. And there's no such thing as separate but equal. That if you separate the races, then you're basically saying that one race is dominant over the other. And so you are not being constitutional. You're not giving equal protection of the laws to an enormous class of American citizens. Well, of course, by the time that rolled around, I just did something. D. Okay, I'm back. Sorry. So technical difficulties there. So here we have the Constitution passed in 1787, all the way to 1954, before the black race, if you will, African Americans, former slaves, are given equal status under the law. The United States Supreme Court, in Professor Chermeninsky's opinion, and in the opinion of most people that analyze the Constitution, the whole purpose of the Supreme Court was to protect the rights of minorities. We already have majorities, right? I mean, if you are in the majority, then you can go to your Congress and you can pass laws. But if you're a minority, like the African American race was, they couldn't pass laws because they were in the minority, of course. And in fact, based upon some of the laws passed by the white race, the Jim Crow laws and so on in the South after the Civil War, and the Voting Rights Act, which continues to be voted down. There's a very recent case by our current Supreme Court that ruled that the Voting Rights Act and some of these the new law that was passed was unconstitutional, and that the Voting Rights Act, and it was our current court even sometimes does not protect the rights of minorities as it should. And that is the fatal flaw in the United States Supreme Court, that throughout its history, when it's had a chance to protect the right of minorities, it has not done so. And that is the fatal flaw. Why in the world is that? We have these men, and now some women. They're appointed for life. They are not subject to political pressure. They can't be removed. They stay there forever. They don't have to run for office. They don't have to go get campaign contributions. And yet they consistently, throughout the history of the Supreme Court, they vote generally with the more powerful interests. They vote with the government. For instance, why in the world didn't the Supreme Court between 1787 and 1860, why didn't they chip away at this slavery question? So that ultimately, if the Supreme Court had declared slavery unconstitutional, which they could have, it's in the Constitution, that people are entitled to, it's inherent in the Constitution that slavery as an institution was unconstitutional. It had been banned in England as early as 1833. And here we were coming along in this Dred Scott decision in the 1840s, which is basically saying that no, slavery is alive and well. And so why is the Supreme Court siding with all of these slave owners when, in fact, they should be chipping away and protecting the rights of minorities? It's really not until you start getting to the Warren Court. You know, Chief Justice Earl Warren, he was a former governor of California, and he came in 1954. He actually came in the year of Brown. And it's actually fortunate. There's when you look into and analyze how the Brown versus Board of Education decision was decided, it was almost kind of a fluke, because had it been decided a little bit, it actually was before the court, and then it didn't get decided. And also, I keep hitting my mic here. Okay. And it was a kind of a fluke that fortunately, by the time it came before the court, Justice Warren had been appointed, was Chief Justice, and we have equal rights for African Americans in school and then so on. But even then, you have states like Virginia, which resisted segregation for many, or desegregation for many, many years. We didn't desegregate here in Virginia until the late 60s. We had politicians that stonewalled, and we had to have all kinds of, we all know about, there's a movie out now, that Selma movie, talking about voting rights in the 60s. And it is just fascinating that we have a Supreme Court that for more than 150 years refused to grant equal status to such an enormous number of our citizens, more than 150 years of this kind of discrimination by the institution that was put there to protect the rights of minorities. And also some fascinating bad decisions by the, we've had several times on my show, and you can go to my website, ghylaw.com, and see some of my podcasts. We've also are on archives.org, but you can go. I had Jerome Joseph on my show sometime last year. He wrote a book called Black Mondays, which also chronicles the bad decisions of the Supreme Court. But this idea about how the Supreme Court consistently ruled against the rights of African Americans and slave owners for this many years is just, it's a little scary. And yet we hold up our Supreme Court as this great institution. I mean, don't we revere it? Don't we say, oh, we have the United States of America, we have this fabulous Constitution, we have these three great branches of government, the legislature, the executive, and the judicial, and we protect the rights, and we have all this Constitution, the Bill of Rights, and so on. And when you look at the track record in many of these decisions, and anyway, we're going to have Professor Chermeninsky on with us in just a few minutes. He's going to address some of these some of these issues and others, and I'm really looking forward to having him. So we're going to go to a short break here, and when we come back, we're going to have Professor Erwin Chermeninsky. He's a professor of law at the Cal Irvine Law School, and he's the author of The Case Against the Supreme Court, and you get a chance to listen to my conversations with him. So we'll be right back.
If finances are holding you back from enrolling your kids or grandkids in private Christian schools, call the radio station at 488-1010. We have a partnership program with several schools on the peninsula and the south side that allows us to offer a 35% discount off tuition for preschool through the 12th grade. Give us a call today at 488-1010 or visit our website at tuitionsolution.org. Did we mention we added daycares to the site? tuitionsolution.org.
What do you get when you cross a former prosecutor turned criminal defense attorney with radio? A variety show that is sure to spice up your Saturday afternoon. Tune in each Saturday at 2 p.m. for Justice for All. Each week, host George Yates will tackle current events, interview fascinating authors and guests, and offer advice on your legal issues. Visit ghylaw.com. That's ghylaw.com, and click on the radio show button to listen online and to archives.
Nor'easter season is here, so don't get all wet. Protect your house. Call Crawl Space Door Systems at 363-0005. Reduce your flood insurance, reduce the threat of mold and insects, and save energy. Crawl Space Doors, air vents, flood vents, vent covers, and fans can help you stay dry or get you dry quickly. Contact Crawl Space Doors for more information at 363-0005 or online at crawlspacedoors.com. Stay dry, my friends.
Hi, this is Greg Bigoveris. Join me for Sports Scene each Wednesday from noon to 1 right here on News Talk 1650 WHKT. You can also hear the show on TuneIn as well. We will talk to local, regional, and nationally acclaimed sports guests, and we'll interact with our audience as well at Greg Bick on Twitter. Sports Scene, Wednesdays from noon to 1 right here on 1650 AM.
Okay, we are here. We're welcome back to Justice for All. I'm George Yates, and we'll spend the next 30 minutes or so, hopefully longer, but we're with Professor Erwin Chermeninsky. He's a professor of law at the University of California, Irvine. He has argued many cases before the United States Supreme Court and is the author of the leading law school textbook on constitutional law in the United States law schools. His recent book, The Case Against the Supreme Court, takes the position that our Supreme Court is just really not the institution that that we all have revered as being so above the law or doing the right thing with the law. And Professor Chermeninsky has analyzed many cases since the inception of the United States Supreme Court and has kind of determined that the court has often upheld discrimination and egregious violations of basic liberties more often than we would like, and maybe more often than the Founding Fathers envisioned that it would. We have Professor Chermeninsky with us today, and welcome to Justice for All, Professor.
It's a pleasure to talk with you. Thank you for having me on.
Well, I read this book, and it's a very lengthy and well documented, well thought out book. You have some pretty rough opinions on the United States Supreme Court.
The thesis of the book is that the Supreme Court has often failed. Often in the most important times, often in the most important tasks through American history.
You cite so many cases. What would be some examples of egregious violations of basic civil rights that you find violate what, let's say, the Founding Fathers envisioned the United States Supreme Court to do?
Well, I start in the first chapter after the introduction by talking about the Supreme Court and race. From 1787, when the Constitution was approved, until 1865, when the 13th Amendment was adopted, not once did the Supreme Court hand down a ruling to lessen the rights of slave owners or to protect slaves. Every court case during this time aggressively protected the institution of slavery. From 1896 to 1954, a period of 58 years, the Supreme Court said that separate but equal is constitutional, and the court enforced the Jim Crow laws that segregated every aspect of Southern life, laws that made sure that it was anything but separate but equal. And we can talk as recently as June of 2013, when the Supreme Court declared unconstitutional key provisions of the Voting Rights Act of 1965, the first time since the 19th century that the Supreme Court has declared unconstitutional a federal civil rights law dealing with race. One more example, we can talk about the Supreme Court in times of crisis. Can look at Korematsu versus United States from 1944, where the court upheld the evacuation and internment of 110,000 Japanese Americans, aliens and citizens, in what President Franklin Roosevelt called concentration camps.
This is quite a betrayal. What did you envision? What is the, in your view, as a constitutional law scholar, what were the Founding Fathers looking for in a Supreme Court? And based upon that, do you believe that the Supreme Court, as it has acted, has betrayed those expectations?
The role of the court is to enforce the Constitution. I think the Constitution exists especially to protect minorities. The majority can usually protect itself through the political process. But it's so important to have a Constitution and a court to safeguard minorities. For the framers, they would have thought of this in terms of political minorities or religious minorities. Today we think of it in terms of racial and ethnic minorities, sexual orientation minorities. The framers also wanted to make sure that the Constitution protected our most precious values in times of crisis. The framers knew from world history that all too often in times of crisis there's a temptation to centralize power and repression. And it's the role of the court then to effectuate this. I think that the Supreme Court has at times succeeded, but too often it's failed.
You, throughout your book, have a theme running all the way through it, that whenever there is a battle between the more powerful and the least powerful, the court seems to always side with the more powerful. And that surprises you because your thesis is that, as you just said, the majority can protect itself through the legislative process, and the least powerful cannot do so. And yet the Supreme Court seems to always side with the most powerful. Is that what you've discovered?
It is that all too often through history, and especially now, the Supreme Court is favoring government power, corporate power over individuals, people like us, consumers, employees.
Well, that one decision, what's the decision from California regarding the arbitration clause, where somebody has to, they can sign one of these contracts of adhesion and they can be, can't become a member of a class?
Well, that's exactly right. It was a case called AT&T Mobility versus Concepcion. And what was involved here was AT&T was advertising free cell phones to those who subscribed to its service. The Concepcions went in to get their free cell phones. They, like all of us, signed the agreement. They, like most of us, didn't read the agreement. There was an arbitration clause. If they had a dispute with AT&T, they'd have to go to arbitration. They believed that AT&T committed fraud in its billing, and they each thought that they were entitled to $32.80. No one's going to go to arbitration for $32.80. We need a class action suit for situations like that, where a large number of people each lose a small amount of money. But the Supreme Court 5-4 said they couldn't be part of a class action. They had to go to arbitration. This is one of a number of Supreme Court cases that's aggressively protected corporations, enforcing arbitration clauses, keeping injured people from having their day in court.
And the Supreme Court seems to always favor judges. They've given themselves immunity, all judges. They've also, when members of the military forfeit all of their constitutional rights once they join the military, according to Supreme Court law. It just, there's so many decisions that just take away the rights that most people envision that the Constitution guarantees them.
I think one of the important things that you touch on that gets very little media attention is how the Supreme Court has made it often impossible and certainly frequently difficult for people who are injured to be able to bring lawsuits. So if a judge does something egregious violating people's rights, judges can't be sued. There's a very famous case where a woman of a teenage daughter went to see a judge in his chambers and said, "I'm worried about my daughter. I don't think she's very bright." The daughter was at grade level and always passed at grade level. And the mother asked the judge to sign an order to have the girl surgically sterilized. The judge signed the order. The girl was told she was having an appendectomy when a tubal ligation was performed. Only years later, when she was married and couldn't conceive a child, did she learn what had happened to her. No case had ever been filed in that judge's court. No docket number was assigned. The girl was given no notice. The judge had no authority under Indiana law to do this, and yet the Supreme Court said a judge can't be sued for money damages. There's another case where a witness didn't show up in court, and the judge from the bench said to the bailiff, "Go find the witness and rough him up." The bailiff went and found the witness and beat him up. The witness sued the judge and said, "It's not a judge's power to order somebody to beat up," but the Supreme Court said the judge could not be sued for money damages. Judges have absolute immunity.
Well, actually, the Supreme Court is able to declare federal laws unconstitutional, and yet the Constitution itself does not give them that power. I guess John Marshall, in the very famous case of Marbury versus Madison, the one that we all read in law school, the first one in the constitutional law book, the Supreme Court gave itself that power as well, didn't it? The Supreme Court didn't have that power under the Constitution. It gave itself the power of judicial review.
That's an issue that will never be settled or resolved. The Constitution doesn't specifically mention a power of the courts to declare laws unconstitutional. But many believe that it was always assumed that courts would have this power. Alexander Hamilton, in Federalist number 78, spoke of courts having this power. A lot of what John Marshall wrote in Marbury versus Madison just comes from Federalist number 78. And yet, whether or not it was intended that courts have the power, they've certainly had the power since 1803. I think overall that's a good thing. I think John Marshall got it right in Marbury versus Madison. The limits of the Constitution have meaning only if they're enforced. We need the courts to be there to enforce the Constitution when the other branches of government violate it.
But wasn't there a period in the court's history, as you write in your book, from the turn of the century in 1900 to about 1937, where the United States Supreme Court just struck down virtually every single federal law that was passed in order to protect the rights of minorities and labor workers and that sort of thing?
You're right. From the 1890s through 1936, the Supreme Court struck down over 200 federal, state, and local laws that were designed to protect employees and consumers. The very first federal law limiting the use of child labor was declared unconstitutional during this time. Minimum wage laws, maximum hour laws, consumer protection laws of all sorts were declared unconstitutional during this period of about 40 years.
And what was the basis to declare those kinds of consumer protection laws unconstitutional when now they're considered perfectly constitutional today? How did the law change?
It was a Supreme Court at that time that was very economically conservative. It believed deeply in a laissez-faire, unregulated economy. And it was very hostile to economic regulations to protect employees and consumers. Now, one of the things the court did during that time was say that freedom of contract is a fundamental right, and laws that interfered with freedom of contract were declared unconstitutional. So if a state adopted a maximum hour law or a minimum wage law, the court would say, this interferes with freedom of contract, the ability of the workers to contract to work for more hours or less in wages.
Are we headed back to that, you think? Because it seems we, under the Roberts Court, we have a very similar pattern here of moving towards this infringing on the rights of people to sue, as you've just mentioned, that AT&T case. And are we headed back to another period under the Supreme Court as we had during the turn of the century till 1937?
Yes and no. The no first. I don't think the court's going to use the same principles and doctrines it did during that era. They're not bringing back freedom of contract as a limit on government power. But yes, we are in an era right now of the most pro-business Supreme Court that there's been since the mid-1930s. A study was done by Richard Posner, who's a judge on the Seventh Circuit, William Landis, a professor at the University of Chicago Law School and Business School, and also Lee Epstein, now a professor at Washington University in St. Louis. And they came up with a number of measures, and by all of them they concluded, excuse me, this is the most pro-business Supreme Court that there's been since the era we were talking about that ended in 1937.
What is the role of politics anymore? I think that your average citizen out there thinks that the United States Supreme Court, these 9 men and women in their robes, they see it as John Roberts said at his confirmation hearings. I'm just calling balls and strikes, like an umpire. But we all know that John Roberts has a strike zone that's quite a bit different from yours or mine. How is it that politics enters into the Supreme Court? Other Supreme Courts, certainly this one that has all these 5-4 decisions with Justice Kennedy, the swing vote. It's so predictable anymore as to what you're going to get in any kind of decision. How in the world did it get this way?
I want to be careful in the terminology we use. In one sense, the Supreme Court's not political. The justices don't have to run for re-election. They don't have to raise money for their campaigns. No one can lobby them. There's no trading of votes on the court. And if that's what we mean by politics, we accept all of that in the legislature. It's not what the Supreme Court is about. In another sense, though, if what we mean by politics is the ideology of the justices, then the Supreme Court is very much a political institution. The Constitution is written in very broad language. What's cruel and unusual punishment? What's equal protection of the laws? How do you balance competing rights? All of this turns on the views and ideology of the justices. So the justices aren't just calling balls and strikes. They're deciding the rules of the game. They're deciding what the strike zone is. And so I think Chief Justice Roberts should be ashamed of that analogy because he knows it's inept.
What is the role that you suppose so many of the backgrounds of these justices? I had a great interview with Joel Cohen. He wrote a great book called Blindfolds Off. I don't know if you had to get a chance to take a look at that book, but he interviewed 12 or maybe 13 federal judges and discovered a wide range of how they ruled on cases. And one of his judges even chastised so many other judges because they come from the elites in society. And so as is one of the elites in society and coming only from Harvard and Yale, I think, our current Supreme Court, to what extent you suppose the fact that they come from elites, I suppose, other than, I guess, Justice Sotomayor, and the backgrounds of judges. Do you think that has anything to do with the fact that they seem to side with the elites when it comes to ruling on, let's say, whether or not a corporation or an individual is going to prevail in a lawsuit?
Of course it does. How a justice exercises his or her discretion is a function of the justice's life experiences, the justice's values and views. On the current court, two of the justices, Clarence Thomas and Sonia Sotomayor, grew up in disadvantaged backgrounds, and it's interesting they drew very different conclusions from their upbringing. But judges at all levels are human beings, and how they approach their job is a function of their life and their values.
It seems that we need to get more justices that came. Of course, we had, what was it, Warren Berger. Didn't he go to night school, I think, up in Minnesota or something like that?
He did.
And he was a very good...
That's not the current court. The current court, they all went to Harvard or Yale, except for Justice Ginsburg, who started at Harvard and finished at Columbia when her husband graduated before her and took a job in New York. And I don't want to criticize Harvard and Yale. I went to one of those law schools myself. But I do think it's a court that could use much more in the way of diversity, of educational and life experience. Every borough of New York has a justice who grew up there, except for Staten Island. Only 2 of the 9 justices grew up west of the Mississippi, and only 1 of the 9 justices was appointed to the court while living west of the Mississippi.
Yeah. Well, listen, I got a couple of questions here before we go. First of all, I know you've argued some cases before the Supreme Court, and that's a fascinating idea. Tell us what it's like to go. You mentioned a little bit of that in your book. And by the way, this is George Yates, and I'm here with Justice for All, and I'm here with Erwin Chermeninsky. He wrote The Case Against the Supreme Court. Your book's available on Amazon, I'm sure, isn't it, Professor?
It is, of course.
And
it's published by Viking, and it's a trade press, and it's written for a general audience. It's not meant just to be for lawyers and law professors.
No, and it's an easy, great read, and I will tell you, I read the entire book. I've got all my little pencil notes, and I've underlined it, and really a fascinating book. I had Jerome Joseph on my show last year. He wrote that book, Black Mondays, and also citing some of the same cases that you have in your book, and we can't go through all of them. But what's it like arguing a case before the Supreme Court? You're a bit frustrated by it, I think, in your book because you get peppered by so many questions you can't answer. The statement time to talk is so short. You're not allowed any follow-up argument. It must be a frustrating experience being in front of all those justices and not even really being able to answer the question before you're asked another one.
It's incredibly exciting, and as you say, it's incredibly frustrating. It's exciting because this is the chance to participate in shaping the law. What the Supreme Court says, for better or worse, is going to be the law. There's a real awareness of the consequences of it. There's certainly a strong desire to not want to embarrass oneself. I regularly argue cases in the Federal Courts of Appeals. I argued a case in the Federal Court of Appeals of the Ninth Circuit a week ago Monday. And there's not this certainly tremendous awareness of the importance of the case and a desire to perform well. But I think in the Supreme Court, I'm much more focused on, I don't want to embarrass myself. I don't want to have that horrible moment of wanting the floor to open up and swallow me.
That must be.
It's also very frustrating, as you say. Mm-hmm. The justices have very little respect for one another's questions. And so the result could be, I'll tell an instance of a case I argued several years ago, where Justice Stevens asked me a hypothetical. Before I could answer, Justice Kennedy said add this to the hypothetical. Before I could answer, Chief Justice Rehnquist said add this to the hypothetical. I got one sentence out in response to what Chief Justice Rehnquist had said, and Justice Scalia then asked me a question, but something totally different. Last year I argued a case in the Supreme Court, and there was one question that I knew was going to come, and it was really important. And I worked and worked and worked, and it got down to a 3-sentence answer. Justice Breyer asked me the question. I was ready for it. I got the first sentence out, and then Justice Alito asked me a question about something else, and I never got out the last 2 sentences.
And they're not going to let you just keep talking over their question. Unfortunately,
Nope.
Once they start to talk,
Yep.
you have to stop, don't you? Not much collegiality, I guess, between the brethren, huh?
Well, I think that there are more justices on the current court that just want to get their 2 cents in. They want to ask their questions. And this isn't ideological. I think that studies have shown that both Justice Scalia on the right and Justice Sotomayor on the left tend to dominate questioning. There have been studies done. In fact, a professor at Loyola Chicago, Barry Sullivan, has done a study counting the amount of questions per argument and the amount of time that the justices spend talking. It's gone up tremendously.
And Justice Thomas never asks any questions, I understand.
He last asked a question in 2006. That's not an exaggeration. It's not hyperbole. That's when he last asked a question.
So what's the worst case in recent years, would you say, from the United States Supreme Court? What's the one that sticks out? I mean, I guess Bush v. Gore was pretty ridiculous.
Citizens United versus Federal Election Commission.
For those of us, and there also FCC versus McCutcheon, isn't that one of the newer ones?
McCutcheon versus Federal Election Commission was just last May.
Right.
Citizens United is 5 years old. It was decided on January 21st of 2010. And it held that corporations can spend unlimited amounts of money from their corporate treasuries to get candidates elected or candidates defeated. And it's had a dramatic effect on elections in the United States.
And was that a 5-4?
It was. Justice Kennedy wrote for the court, joined by Chief Justice Roberts, Justice Scalia, Thomas, and Alito. Justice Stevens wrote the lead dissent, joined by Justice Ginsburg, Breyer, and Sotomayor.
And this was a decision that says basically that corporations are people.
It says, at least with regard to freedom of speech, that corporations have the same speech rights under the First Amendment as individuals, so the government cannot limit corporate expenditures in the context of election campaigns.
But aren't these corporations owned by you? You can be a foreign person and literally own a controlling interest in a corporation. You're not a United States citizen, and you can donate any amount of money that you want to affect American elections, and you're entitled to freedom of speech even though you're not a citizen.
To this point, it's limited to United States corporations, regardless of who owns them. There are still in place laws that limit the ability of foreigners or foreign corporations to spend money. Whether those laws will be upheld, we don't know.
Well, doesn't Citizen United also, though, give great power to, like, labor unions as well? So can't the left, I mean, what this does is it gives amazing power to the right and to corporations, but doesn't it also give power to, let's say, to unions, and they would generally go for labor and the left?
By implications, the case means that both corporations and unions can spend unlimited amounts of money in election campaigns. However, studies show that nationally, corporations spend 15 times more than unions in election campaigns. Mm-hmm. Also, the Supreme Court, in recent decisions, has greatly limited the ability of unions to raise money, and those cases are going to make it harder for unions to be on the same playing field with corporations.
Yeah, unions are on their way out, I would guess, because they get too many states have right to work laws, like here in Virginia where we're talking from, and so on. And a union, and maybe that's a good thing. I don't know, because maybe there's other laws in place now that unions aren't as important as they were back at the turn of the century. What do you think?
Well, that's a whole other topic to have on. I actually think that unions are not on their way out, though they have the smallest membership and smallest percentage of employees in decades. I think unions are a crucial counterforce to corporate power. If not for unions, who's going to be there to protect the employees? And as corporations become all the more powerful, I think it's essential that there be powerful unions as well.
Well, so what do you think going forward? What would make the Supreme Court a better place than it is now? I know you have some ideas as to what would make it better, and I guess it's probably not going to happen, right? But you just have some ideas. Or what are the chances?
Some of them might. Some of them are more difficult. In the last chapter before the conclusion, I posed many reforms to the Supreme Court. I start by saying that I think the court should clearly articulate its role, and we as society should articulate its role as enforcing the Constitution, protecting minorities, especially in times of crisis. I argue for changing the selection process for Supreme Court justices. I argue that a president should create a merit selection commission, make it bipartisan, require that 2/3 of the members agree to a nominee, and the president should promise to pick only from within those names that have been forwarded to him or her by the Merit Selection Board. Jimmy Carter did this to great success for federal district court and federal court of appeals judges. He never got a Supreme Court vacancy to fill. I argue for changing the confirmation process so that no longer is what Joe Biden referred to when he was a senator as an exercise in kabuki theater. I argue for 18-year non-renewable terms for Supreme Court justices. Life expectancy now is thankfully a lot longer than it was when the Constitution was written. Clarence Thomas was confirmed for the court in 1991 when he was 43 years old. If he remains on the court until he's 90, the age with Justice John Paul Stevens retired, he will be a justice for 47 years. That's just too much power exercised by one person for too long a period of time. I argue we should change how the court communicates with the American people. As an example, there should be cameras in every Supreme Court proceeding. I argue that the ethical rules that apply to all other federal judges should apply to Supreme Court justices as well.
Because I noticed in your book you talk about how Clarence Thomas' wife had accepted more than $600,000 from a conservative group that was opposed to the Affordable Care Act. And on his disclosure forms, year after year after year, he declared that his wife had no income. And he didn't he in fact sit on that last opinion on the Affordable Care Act last year?
Yes.
How do they get away with number one, filing that looks to me like a felony, I would suppose, right? Or
maybe... Well, it's not, but what he did, year after year, he had to fill out a form that had to disclose his wife's income. Just like I, as a state of California employee, have to disclose my and my spouse's income. And he, year after year, checked his wife's income as zero, even though she had a six-figure income. That's just inexcusable. He said he misread the forms. This is the same justice who, when a person missed a filing deadline by 2 days because the federal judge had given the person the wrong information about the filing deadline, Justice Thomas wrote the opinion saying, tough, the person was out of luck. Also, right now it's left to each justice to decide for himself or herself whether to be recused in a case. I think that's wrong. Nobody should be a judge of himself or herself.
Well, that's it. Well, don't often. What are the rules for a federal judge to recuse himself if somebody comes up and says, "Judge, we think you have an interest"? Does every federal judge have that right, or only the Supreme Court judge? Does someone else make the decision on recusal in federal court?
That varies by area. In most places, somebody else other than that judge will make that determination.
What, in your opinion, was the best court? You call yourself a liberal in your book, but then you also say that even though you kind of have a liberal viewpoint, you try to approach your book from a bipartisan standpoint, certainly from an objective standpoint. But in your opinion, what was the best run court, and what's the worst run court in history?
I think that the best run court in history and the best court in history was undoubtedly the Marshall Court. John Marshall articulated a framework for government that survives to this day. I think the worst court in history was the so-called Lochner Court from the mid-1890s to 1936, which I think frustrated a tremendous amount of social progress, and many people suffered as a result.
And that was the court that also decided separate but equal, Plessy v. Ferguson?
Right.
And they were the one, that same court that struck down all those laws based upon the sanctity of a contract.
That's exactly right.
And how do you rate the Roberts Court? What do you think it's going to be like going forward? That's the current one.
I think we've already, of course, the Roberts Court is in its 10th year. What I mean by that is the 10th year of John Roberts as Chief Justice. John Roberts is just turning 60 years old this month, so he could be on the court another 30 years. So if the Roberts Court is 40 years, we've just seen the first quarter of it. Hard to know what it's going to be doing in 20 or 25 years. I think what we see from the Roberts Court so far is an overall very conservative court and an overall very pro-business court.
And we're going to have some, a decision on gay rights coming up now. I guess they decided to take an opinion. I thought that they denied cert earlier this year, and everybody was saying that they were just going to pass on it and let the states work that out. And then, lo and behold, they decided to take on the gay marriage issue. What do you make of that?
Well, the court earlier, in October of 2014, denied review in cases coming from the 4th, 7th, and 10th circuits that had struck down state laws that prohibited marriage equality. Soon after doing that, the United States Court of Appeals for the 6th Circuit out of Cincinnati upheld laws in Kentucky, Michigan, Ohio, and Tennessee that prohibited same-sex marriage. Once the Sixth Circuit did that, there was then a split among the lower courts, and that's when the Supreme Court steps in. And that's what they did here, is they waited until there was a split, and then, not surprisingly, on Friday they took the cases involving marriage equality concerning these 4 states.
I'm assuming that the process for selecting Supreme Court justices is going to remain the same going forward. We have 2 more years of the Obama presidency. Do you think he's going to have an opportunity to select another justice, or is anybody planning on stepping down?
My guess is that neither Justice Ginsburg nor Justice Breyer, and they're the 2 oldest among the liberal justices, are going to step down this summer. They think that with the Republican Senate, the ability of President Obama to pick their successor is limited. Certainly, I don't expect older of the conservative justices, Justices Scalia and Kennedy, who are each 78 years old, to step down this summer. But when you're dealing with individuals who are 82, 79, 79, and 77, there can always be unexpected vacancies.
Yeah, and what is so fascinating about this is, as you mentioned earlier, Jimmy Carter spent 4 years as a Democrat, didn't get a chance to appoint any justices, and we do find that it's kind of luck of the draw. You might have a Republican president for 8 years, and he might appoint 3 or 4. Then you might have another president for 4 years or 8 years and not get a chance to appoint any, depending upon how young they are. And yet with the immense power of the Supreme Court to make these decisions that have precedent that go forward for decades, it's really an extraordinary situation, the power of the president to appoint a Supreme Court justice under the present system, isn't it?
It's one of the most important things, one of those long-lasting things that a president does. And I hope as we get towards the 2016 presidential election, a great deal will focus on that. With justices as the ages we've just been talking about, it seems so likely that the next president will have maybe as much as 4 vacancies on the court. When you think of justices being there for decades, it should be a key issue in our political process.
Well, listen, I know that you said you were going to give us 30 minutes, and I think we've just bumped right up against that time limit, Professor. For those of you that have just joined us, we've spent the last 30 minutes with Professor Erwin Chermeninsky. He's a professor of law at University of California, Irvine. And he's got a great resume. Of course, he's the founding dean, distinguished professor of law there. He's argued cases before the United States Supreme Court on numerous occasions. He writes the leading textbook on constitutional law in the law schools in the United States. And he is the author of this recent book, The Case Against the Supreme Court, by Erwin Chermeninsky, and it's really fascinating reading. It is written for a layman, and it's great stuff, and it's available on Amazon. I would urge you to go out and buy it if you're listening to the show, and if you want to hear more about, you can always come back and listen to the rest of the interview on the podcast here later on. You can get it on our website. So, Professor, I'm going to let you go here.
Thank you so much, and I hope we can do this again sometime soon.
Okay, great. Have a great day. Thank you so much for coming on the show.
Thank you.
All right, well, that leaves us with the rest of our show. What we're going to do is take a short break here. And as I said, that was Erwin Chermeninsky, The Case Against the United States Supreme Court. A fascinating book. And that was a very fascinating, interesting discussion with him. So anyway, we're going to be right back with the rest of Justice for All. And stay with us.
RM Designs T-shirt printing and more is located in Smithfield, but serves all of Hampton Roads. They specialize in vinyl design shirts, apparel, window stickers, cups, and other specialty gifts. They also have rhinestone and embroidery designed apparel, and they offer Pandora-style beads and hardware to create a one-of-a-kind piece of jewelry. RM Designs T-shirt printing and more caters to businesses, sports teams, churches, groups, and family reunions. They also offer a great fundraising package should you be in need of money for a special project. And they also do home parties if you and your friends would like to get together and make your own creations. RM Designs T-shirt printing and more can be reached at 757-255-9140. That's 757-255-9140. Email them at rmdesigns11@aol.com or find them on Facebook at RM Twisted Designs. You can also place orders directly off their store at storeenvy.com/RM Twisted Designs.
Leaky faucet, refinishing old countertops? Hey, Gary Sullivan here. Perhaps you're restaining a deck or painting your living room. Whatever it is, let me help. I'm here to give you the tips you need to finish those pesky projects you've been putting off. If you're restaining, I have a tip for that. Can't get the paint off the hardwood floors? Got a tip for that too. I'm here to make sure that $5 repair doesn't turn into a $500 repair. Join me right here every weekend.
Saturdays at noon, Sundays at 9 a.m. on AM 1650 WHKT, The Answer.
Bay Propeller is the region's best prop shop. With 25 years under his belt, Max Allen and a team of highly skilled techs provide fast, quality service on all types of boat propellers. From 8 to 80 inches, Bay Propeller utilizes MRI propeller scan technology and dynamic spin balance. Distributor for many brands, Bay Propeller ensures you get the right propeller for your needs at discounted prices, with emphasis on made-in-the-USA propellers. Bay Propeller, next to Portsmouth Trailer Supply in Chesapeake. Call 485-5681. BayPropeller.com.
Coulter. ISIS may have executed one of the 2 Japanese men it's been holding hostage in Syria, but an online posting purporting to announce the death has not yet been authenticated. CBS's Holly Williams has more.
This is new audio recording, which is purportedly of Kenji Goto speaking in English and demanding a prisoner swap, turns out to be authentic. That's another change in tactics. Once again, we don't know why ISIS may be moving in that direction.
ISIS was demanding $200 million for the release of the hostages, but now it wants a female terror suspect released in Jordan. Spanish police have arrested 4 men suspected of planning a terror attack. CBS's Larry Miller has details.
In morning raids on 2 houses, Spanish police arrested 4 suspected Islamic terrorists who were allegedly ready to carry out an attack. The arrests were made in the Spanish area of North Africa bordering Morocco. The suspects are 2 pairs of brothers. Spain's interior minister says they are highly radicalized, military trained, and ready to blow themselves up. He says there are strong similarities with the 2 French brothers who attacked the Charlie Hebdo office in Paris. Larry Miller, CBS News, London.
Republicans with an eye on the White House are taking part in this weekend's Iowa Freedom Summit. Some big names in the GOP are no-shows, but CBS News senior political editor Steve Chagaris, who's in Des Moines, says that may not hurt them.
Republican officials are stressing that just because Jeb Bush or Mitt Romney are not here at this event doesn't mean there aren't plenty of opportunities for them to meet and greet Iowa voters over the next year.
Among those at the summit, Wisconsin Governor Scott Walker, Donald Trump, and Texas Senator Ted Cruz. It may be hard to believe, but there are veterans homeless on the streets of the nation's capital. WTOP's Dick Uliano says many are getting help today.
It's the VA Medical Center's 21st year of identifying vets among the city's homeless to give them the care they earned and need. 11-year Army veteran Kevin Robinson is among the hundreds getting health screenings, vaccinations, and dental care.
I'm getting the best of the care that I need, stuff that I want, I'm getting.
Women, too, are among the city's homeless vets, and Gail Bell, who runs the Women's Clinic, expects to treat up to 100.
Every year we've noticed our numbers have increased.
The vets are also getting employment, education, and financial counseling, even warm clothes and boots for those who need them. Dick Uliano for CBS News, Washington.
A British nurse who contracted Ebola in Sierra Leone has been given a clean bill of health and released from a London hospital. Pauline Cafferty says she's looking forward to resuming a normal life.
I was definitely frightened, but Ebola is so unpredictable.
The Liberian government said